Good evening, students. Tomorrow you are having the exams of law of torts. So here in law of torts, in unit number 5, you are supposed to write the answer either for the Consumer Protection Act or Motor Vehicles Act. Here, with regard to the Motor Vehicles Act, what are all the things you have to write? What are all the things you are supposed to write? And what are all the contents you are required to cover? So with regard to the Motor Vehicles Act, probably you have got the idea with regard to the Motor Vehicles Act. So under which a mechanism has been adopted for the payment of compensation to the victims or LRs of the deceased. And this is a common conception among us. So here, which are all the questions which are going to come in the examination with regard to the Motor Vehicles Act? Probably if you see the previous question papers, there is a importance has been given with regard to the discuss the special features with regard to the Motor Vehicles Act of 1988. And also the questions will be come with regard to the insurance aspect of the motor vehicles under the Motor Vehicle Act of 1988. And some generalized question may also be given. Discuss the Motor Vehicle Act as a social welfare legislation. So in this way, the question may come, and also they may give with regard to the motor accidents claims tribunal, and they may ask you with regard to the solidarium fund. So in this way, what are the things we have to require to be covered? So here we have to cover from the historical development, from the Fatal Accidents Act of 1885 up to present Motor Vehicles Amendment Act of 2019. So these are all the things we have to require to be covered. Here what we have to see, with regard to the every act, there is some aim will be there, some intention will be there, some object will be there. Let us start from the beginning, that is Fatal Accident Act of 1885. Here, this act has been enabled the injured or the LRs of the legal representatives of the deceased, LRs of the deceased in an accident to proceed against the person committing the negligence. So this is the thing we have to see. And here, as you know, negligence is the concept of tort, and which is considered as the actionable wrong. So here this act was providing some sort of the relief to the victims of these accidents. Later, the Motor Vehicle Act of 1914 has come into being. Then later, Motor Vehicle Act of 1913 has come into being. Then this Motor Vehicles Act of 1988 has been legislated, and it is a comprehensive enactment in respect of the various matters relating to traffic safety on the roads and minimization of the road accidents. So this we have to see, and this we have to see, we have to know. Here there are other accidents, the Motor Vehicle Amendment Act of 1994 is also there. So it is giving much more importance with regard to the eco-friendly vehicles, so which are exempted from the requirements of permits, and which has got the owners of such vehicles shall have the discretion to fix fares and freights for carriage of passengers and goods. That means these are all the government policies to encourage the eco-friendly motor vehicles. Here, here with regard to the compensation aspect under the Motor Vehicles Act of 1988, two things are very much important. One is no fault liability. Another is a fault based liability. So here, what is no fault liability? What is fault based liability? Here, under fault based liability, which aspect has to be covered? So which is the thing which has to be seen? Here under the fault based liability, there we can see the concept of negligence. So here number of literature has been given. So here we don't have the absolutely, we don't have the time to discuss all these things. And I wanted to give certain the idea with regard to this fault based liability and the no fault liability. Here under this fault based liability, the negligence was an important element. Here, to prevail in a suit, generally a victim must also demonstrate that the injurer has breached a duty he owed to the victim. When an injurer breaches a legal duty, he is said to be at fault or negligent. Breach of duty is caused by doing something which is a reasonable man should do under the circumstances. That is, the rule of negligence with the defense of contributory negligence holds injurer liable if and only if he was a negligent and the victim was not. So these are the things here, concept of negligence and legal duty by the breacher. So here, what sort of the duty was towards the victim by an injurer, which will be discussed under the concept of fault based liability. Their contributory negligence, all these things will come into being. But these things will not give any relief to the victim. This will deter him from getting the relief from the injurer. Here, that's why the rule of strict liability has been adopted to help the injurer. So here the aspect of who was at fault, that is the 1988 Act, which has given much more importance with regard to the not concerning with regard to the fault based liability. Here, this Amendment Act of 1988 brought an element of strict liability. That means here section 140 was introduced in this amendment. That is this is a very important the section, that is 140 and 163A. Here, what here the how this section 140 is relevant means it provides for the liability to pay compensation in certain cases on the principles of no fault. That is the gist of the section 140, and it has gone to such an extent that here this section 140 of the Act, it does not, it is applicable even where the death is result or the consequences of the accident arising out of a motor vehicle. That means during the accident, probably you know which are all the sections will be there. So ultimately the person succumbs to injury, there will be 304A. So at the time, whether this section 140 is applicable, so what sort of the parameter has to be adopted? So that has been set in the Satwant Kumar Harjit Singh versus Arati Jayant Lalwani. Satwant Kumar Harjit Singh versus Arati Jayant Lalwani. Even at the time of accident, the victim has not been succumbed to injury. Later, due to the consequences of an accident arising out of the use of motor vehicle, the victim succumbs to injury. At that time also, the compensation has to be paid. So this is the important relevant aspect we have to see from the concept of the Motor Vehicles Act of 1988. That means it has given much more importance with regard to these aspects. Here the section 163A is also very much important. Here, notwithstanding anything contained in this Act or any other law for the time being in force, the owner of the motor vehicle or the authorized insurer shall be liable to pay the in the case of death or permanent disablement due to accident arising out of the use of the motor vehicle, compensation as indicated in the second schedule to legal rights of the victims as the case may be. That means this is a very, it is a sort of a mare in the overseas, mare in the desert or overseas in the desert. This is section 163A. Here, under section 163A, the compensation has to be paid, notwithstanding any sort of the impediments. Even if there is any reference with regard to the any impediments, so here it overrules the any other act with the interest of the deceased person, their in-laws. So here the claimant shall not be required to plead or establish that the death or permanent disablement was due to any wrongful act, negligent or default of the owner of the vehicle or the vehicle's concerned or any other person. This is a very much very forwarding effect. Here under this Motor Vehicles Act of 1988, which recognizes the limited no fault liability but only in case of death and permanent disablement, here this concept has been adopted. Here one more important thing has been done. Here while deciding on compensation, courts have applied the rule of negligence with the defense of contributory negligence. For instance, if the liability is limited to 50,000 in the case of death and 25,000 in the case of permanent disablement, such compensation can be claimed without establishing any negligence on the part of the owner of the driver of the vehicle. Here, there is no question of proving the thing. Just if what you call there is no question of establishing any negligence. That means as a part of the helping the injured, this act plays to be a pivotal in respect of all the respects. And here what you have to see, here another aspect what you have to see under this act, liability without fault in certain cases. Here liability without fault in certain cases dealt under chapter 10 of the act. Here section 140 we have seen. So here first one is the liability based things, and here liability without fault in certain cases has been discussed. Here two things we have to see. One is no fault liability, another is a fault liability. In no fault liability, the compensation is a must. In fault liability, the negligence will take into account. But even in the case of negligence, in spite of the negligence, some amount will be paid. That means here some amount will be paid to the injured. That means as a matter of right, some amount will be paid. So in fault liability, under section 146 clause 1, which specifies that no person should use or allow using a motor vehicle in public place unless there is in force a insurance policy complying with the requirements of this chapter. That is what it gives the stress, that it gives the stress for the insurance, so that the injured should not go his rights unredressed. That means he should get the compensation. That is the intention of this fault liability. So under section 145 to 164, which provides for the compulsory third party insurance, which is required to be taken care by the every vehicle owner. Now suppose if it does not make the insurance, so he is going to contravene with regard to section 146, which is a punishable offence up to a period of 3 months or fine up to 1,000 rupees or both. So that has been provided under section 196. So likewise, there are so many things we can see under this the aspect. So we have to discuss section 140 to 144 under the no fault liability. Under the fault liability, we have to discuss 145 to 164. So these are the very important things from the examination point of view. And so here, what is the liability of the insurer? It has to be discussed. So what the insurer has to given, for which aspect he has to given. So here there will be two aspects we have to see. That is, one is the liability, that is the duty of the insurer, and another is the duty of the insurer. First one is the duty of the insurer. Next one is the rights of the insurer to recover the amount which is paid to the victim. So overall, what we have to see with regard to this one here, under this the Motor Vehicles Act of 1988, which are all the things, which are all the important things we have to see, which are all the significant features of this Motor Vehicles Act of the 1988 is that first one is here, which is made to take care of increasing number of both commercial and personal vehicles to the country. And second one is to adopt higher technology in automotive sector. Third one is to maintain the road safety standards, pollution control measures, and to lay down the standard for transport hazardous and explosive materials. And next one is to lay down the effective ways to tracking down the traffic offences. And next one is to lay down the strict procedure for granting renewal of driving license. So here very much important how much currency of the license has to be seen. That means for how much the learner license shall be operative, whether it should be operative for 6 months or how long. It is operative for 6 months. And the license to driver transport vehicle is operative for 3 years. And license to drive transport vehicle carrying the goods of dangerous or hazardous nature is 1 year. And in all other cases, it will be, the person will hold up to 50 years of age. After 50 years of age, the renewal should be done for another 5 years. So here, what you have to see, the procedure has been made with regard to granting and renewal of the driving license. Further, which has laid down the effective standard for standard pollution control devices and licensing of the drivers of the motor vehicle. So here all these things are very much relevant under this the Vehicles Act of Motor Vehicles Act of 1988. So we have to discuss with regard no fault liability, and the insurance of third parties, and significant features of the Motor Vehicles Act of 1988, and powers of the licensing authority has also been discussed. So under several instances, the license authority can revoke the license given to the holder. Suppose he is a habitual drinker, he is addicted to narcotic drug, psychopathic substances, and he misused the motor vehicle in the commission of any cognizable offence, and he is likely to cause the danger to the public, and he holds the driving. He has got the driving license by administrating fraud and misrepresentation, and has committed any nuisance, or he has failed to submit or has not passed the required test. So these are all things we have to see from the examination point of view. That means what are all things, which are all the things which can be important from the point of examination. That means here with regard to hit and run case, it is also very much relevant. Under section 161 deals with the cases where the identity of the vehicles or vehicles involved in accident cannot be ascertained in spite of reasonable efforts in that matter. So what has to be done for such things means, then the Salient fund has to be framed by the government. So here with regard to the Salient fund, suppose the hit and run cases, the identity of the vehicles has not been came into being. So under that time, so the Salient fund scheme has been came into being under section 163 here, 163. That means this scheme came into effect from 1/10/1982. Here some amount has to be given where the identity of the vehicles has not been seen. So here some procedure is also has been given. That means in case of death 25,000, in case of a grievous hurt it is 12,500. Here where the application has to be filed means it has to be filed before the claim settling commissioner. he may be a district collector, a deputy commissioner at district level, and the claim inquiry officer, he will submit the report and he will give the certificate of post-mortem. On that, the claim settlement commissioner, he will make the necessary action. Here, the victim of the hit and run accident or his loss makes an application before the claim inquiry officer in each taluk. In taluk also they can make the application. So this is the thing with regard to Salient fund. So what are all things we have to discuss with regard to hit and run case? It is very much important with regard to these aspects. So here we have to discuss all these things from the examination point of view. Here, with regard to insurance liability beyond the limits of Act and what is his liability and all things here are very much relevant. And one more thing under this Act, there has been the importance has been given with regard to the formation of the motor vehicles claim tribunal. So under section 165 to 175, there is a motor vehicles claim tribunal will be it has to be followed. That is setting up of claims tribunal, procedure to be followed, award or compensation. So under section 165(1), the state government may set up the motor vehicles, the accident claims tribunal, and with the constitution 165(2), that means how many members should be there, and all those things will be discussed under 165 class 2 and under 165 class 4. So how the business has to be done, that means how it has to be functioned. And under 165 class 3, qualification of members has been given, and matter of adjudication of MACT, that has been discussed under 165, and procedure to be followed under 166. That is what sort of the procedure has to be followed. So with regard to what is the procedure has to be followed has been further, it has been given under 166 class 2. That means it should hold an inquiry, summon the parties, fix the liability as per the procedure to pass the award. Here, award of claims tribunal, what is its evidentiary value, how it has to be executed. So these are all things we can see under this the Motor Vehicles Act of 1988. So this is very much relevant with regard to the examination point of view. And we have to discuss the duties of the insurer and the rights of the insurer and defenses available to the party insurer. That means under certain times the insurer has got the defense. Suppose the vehicle, the conditions will be there on the vehicle. That means suppose the vehicle is used for hire and reward purpose, then no compensation can be claimed. And for organizing racing and speed test, no compensation will be claimed. When vehicle is a transport vehicle used for the purpose not allowed by the permit, then also compensation will not be claimed. Likewise, there are certain things are there. Likewise, there is some rates on insurance. Insurer will be there to recover from the owner. Here, the liability of the insurance company is strict. Even the insurance company have defenses. The primary payment to the insured shall be made the primemost aspect. Later, the insurer can recover the same amount from the owner of this vehicle. So these things we have to discuss from the examination point of view. And one more thing, the case on no fault liability, the case law of National Insurance Company Limited versus Onnappa, it is very much important. In this case, it was held that no fault liability, the claimant is not required to prove that the permanent disablement was due to the wrongful act or negligence of the owner of the vehicle. Here, what is not required, that the claimant need not have to prove anything. That means with regard to permanent disablement is due to the wrongful act or negligence of the owner of the vehicle. So in entirety, we have to discuss the historical developments from Fatal Accidents Act to the 2019 Motor Vehicles Amendment Act. Here probably you know recently the heavy penalties has been prescribed under the Motor Vehicles Amendment Act of 2019 for the violation of the traffic the rules. So with regard to those things in Motor Vehicles Act itself 2019, it has been mentioned for this much is the fine for not wearing the helmet, for crossing the zebra crossing. Likewise, so many has been given under the 2019 Act. So in conclusion part we have to discuss, but with regard to the overall the bird's view, we have to see the historical development, salient features of the Motor Vehicles Act of 1988, and we have to write the conclusion part. So this is with regard to the Motor Vehicles Act of 1988. So we have to write the formation of the claims tribunal and all those things we have to write, and no fault liability and fault based liability we have to write, and we have to write the important the salient features of the 1988 Act. So this is with regard to the Motor Vehicles Act, a bird's eye view. I can say it is a bird's eye view. So you can cover the subject with the help of these notes. I think it will be helpful for you from the examination point of view. So these are all the things you have to cover from the examination point of view. Wish you good luck, students.